A 9-0 Supreme Court decision almost never happens. And when it does, it's not because the issue is simple. It's because something has gone so far off track that even the most divided court in modern American history feels compelled to speak with one voice. This week, that's exactly what happened. All 9 justices, originalists, textualists, pragmatists, liberals, conservatives, set aside ideology and delivered a unanimous ruling that will fundamentally reshape constitutional law, police accountability, and the real-world meaning of the Fourth Amendment across the entire United States. In an era where 5-4 decisions dominate headlines and dissenting opinions read like political manifestos, a 9-0 ruling sends a very different message. It tells us the court believes the law drifted too far, too dangerously, and for too long. If you haven't subscribed yet, do it now, because what the Supreme Court just did quietly kills a legal loophole that protected questionable government actions for decades. A loophole so powerful that it didn't just affect outcomes, it determined whether justice existed at all based on nothing more than geography. This ruling marks the official death of what courts called the moment of threat doctrine, and it took the tragic death of a young man named Ashton Barnes to finally force the highest court in the land to intervene. For years, something deeply disturbing was happening behind the scenes in America's federal courts. Most people never noticed it because it wasn't loud. It wasn't political theater. It was technical, procedural, buried in appellate opinions that never make the evening news. But its consequences were life-altering. Imagine 2 identical police encounters. Same facts, same decisions, same use of force, same outcome. One happens in California, the other happens in Texas. Before this ruling, the constitutional analysis of those 2 encounters could be completely different. Not because the Constitution changed, but because the court did. Before this ruling, your constitutional rights could live or die depending entirely on which federal circuit court heard your case. Your Fourth Amendment protections, the right to be free from unreasonable searches and seizures, weren't universal. They were regional. That fact alone should stop you cold. The Constitution is supposed to mean the same thing in Maine as it does in Texas, in Washington as it does in Florida. Equal protection under the law is not supposed to depend on a zip code, a courthouse, or which appellate judges happen to preside over your region. But that is exactly what was happening. In most of the country, federal courts followed the long-established totality of the circumstances approach. Judges evaluated police conduct by looking at the entire encounter from start to finish. Why the stop occurred, how officers behaved, whether their decisions escalated the situation, whether safer alternatives existed, whether the officer's own actions created or intensified the danger. This approach wasn't controversial. It was rooted in decades of Supreme Court precedent and consistent with how the Fourth Amendment had been interpreted since the founding. But in a handful of powerful and influential circuits, the 5th, 2nd, 4th, and 8th, courts adopted a radically different rule, a rule so narrow it bordered on absurdity. They called it the moment of threat doctrine. Under this doctrine, judges were instructed to put on what Justice Elena Kagan would later describe as chronological blinders. Everything that happened before the final moments of a use of force incident was treated as legally irrelevant. Policy violations didn't matter. Reckless tactics didn't matter. Escalation didn't matter. Ignored de-escalation training didn't matter. The only question the court asked was this: in the final 1 or 2 seconds, did the officer perceive a threat? If the answer was yes, the analysis often ended right there. Qualified immunity applied. The case was dismissed, often before discovery, often before trial, often before a jury ever heard the facts. Accountability vanished. Justice became geographic. If excessive force occurred in Houston, your case was often dead on arrival. If the same thing happened in Los Angeles, you might actually get your day in court. This wasn't theoretical. The numbers were staggering. Between 2018 and 2023, federal appellate courts issued more than 240 published opinions grappling with this exact constitutional question. And they disagreed with one another 60% of the time. Let that sink in. More than half the time, federal judges reviewing similar facts couldn't even agree on the basic framework for analyzing the same Fourth Amendment claim. That's not healthy disagreement. That's constitutional chaos. Even more disturbing, the federal government itself exploited the confusion. Government lawyers took different positions depending on where they were arguing. One constitutional interpretation in the Fifth Circuit, the exact opposite interpretation in the Seventh. Same constitution, same government, different answers. Ordinary citizens were the collateral damage. And then everything changed because of a routine traffic stop in Texas that lasted less than 2 minutes. In 2016, Ashton Barnes was pulled over in Harris County, Texas for a minor toll violation, $645 in unpaid tolls. It should have been unremarkable. A citation, maybe a warning. And everyone goes home. Instead, within 60 seconds, Deputy Constable Roberto Felix had unholstered his weapon. Within 90 seconds, he made a decision that most law enforcement training experts would later describe as tactically reckless. He jumped onto the door of Barnes' S moving vehicle. Seconds later, Felix fired 2 shots through the window. Barnes was killed over a toll violation. When Barnes' family sued, seeking accountability, they ran headfirst into the moment of threat doctrine. The lower courts ignored nearly everything that mattered. They didn't examine why the stop escalated. They didn't examine the decision to jump onto a moving car, a maneuver widely discouraged by police training manuals nationwide. They didn't examine whether de-escalation or disengagement was possible. They focused only on the final 2 seconds. Because Felix was in danger at that precise moment, a danger created by his own tactical choices, the court ruled the killing reasonable under the Fourth Amendment. Case dismissed. No trial, no jury, no accountability. The Supreme Court looked at that logic and said, no more. Getting a case before the Supreme Court is extraordinarily difficult. Each year, the court receives between 7,000 and 8,000 petitions. Fewer than 80 cases are accepted. That's roughly a 1% acceptance rate. Barnes v. Felix cleared that bar because it wasn't just about one tragedy. It exposed a nationwide constitutional fracture. Circuit by circuit, the standards were inconsistent. Fundamental rights were being applied unevenly. And the right at issue wasn't obscure. It was the Fourth Amendment, one of the most foundational protections against government overreach. More than 40 organizations filed amicus briefs, libertarian think tanks, progressive civil rights groups, former prosecutors, former law enforcement officials, the Cato Institute and the Constitutional Accountability Center, organizations that rarely agree on anything, reached the same conclusion from different ideological paths. The moment of threat doctrine was constitutionally indefensible. At oral argument, the court's skepticism was immediate and bipartisan. Justice Kagan asked the question that shattered the government's position. Under your rule, could an officer provoke a confrontation, create danger through reckless tactics, and then claim self-defense because of the danger they created? The government struggled to respond. Justice Gorsuch pressed the historical point. The text of the Constitution hadn't changed. The framers didn't analyze government power in isolated snapshots. Why should modern courts? Then came the decision. May 15th, 2025. Vote. 9-0. Justice Kagan wrote for a unanimous court. A court cannot evaluate the totality of the circumstances, she wrote, if it has put on chronological blinders. The metaphor was devastatingly simple. You can't explain a movie by watching its last frame. You can't understand a story by reading its final sentence. From now on, courts must examine everything, the entire sequence of decisions, from start to finish. Officers are accountable not only for the force they use, but for how and why they arrived at that moment. This ruling does not abolish qualified immunity, but it makes it significantly harder to weaponize. Police training manuals are already being rewritten. De-escalation is no longer just a best practice. It's a constitutional requirement. Reckless escalation is now a legal risk. Cities are reopening cases. Insurance carriers are reassessing exposure. And perhaps most remarkable of all, there were no dissents, no hedging, no distancing, no separate opinions questioning the framework. Every justice signed on fully. That is the court saying, this is not debatable. The moment of threat defense is dead. The real question now is whether lower courts will honor the spirit of this ruling or attempt to quietly neutralize it through narrow application. Because the Supreme Court has made one thing unmistakably clear. Context matters. History matters. And constitutional rights do not begin in the final 2 seconds.